Good evening, this is Rahul Reddy live here from Houston, Texas. Rescheduling PC does bring in live sessions every Tuesday from 5 to 6, and we do cover most of the business immigration that people need to know. Emily, what do we have today?
Today we have finally a win for immigration advocates on the F-1 student visa policy that was planned to be blocking online courses even though we're in the middle of a pandemic. So we'll talk about that a little bit. We're finally starting to hear consulates are reopening slowly over a phased process. So we'll update you on what we know so far. We also had a random discussion, I guess you could say, where President Trump indicated he was planning some other bill, executive order. He kept going back and forth between the words to establish some kind of merit-based immigration system. And, you know, obviously we're all in uncertain times right now, but with immigration, things are even more chaotic and uncertain. So how can you prepare yourself? What can you do to try to maintain some calm in this crazy environment?
You said the government has dropped the policy on the online classes system where they said in the ICE website, they clearly said that if it is a completely online course, then they are going to terminate the civic system and then may even deport the students though. Do you think so the government has changed the heart because they like the students, or why did they change their opinion?
Yeah, definitely not. They received a lot of backlash from that policy. We had letters from senators and congressmen being sent to ICE in the Trump administration, and then we had several lawsuits filed. The biggest one was the Harvard and MIT lawsuit that was supposed to have a hearing today on the restraining order that they were trying to get put in place to block this policy, and instead of having a hearing, they came out with, by the way, we decided to settle and we're going to rescind this policy and stick to the previous policy that came out in March. So we're still not with the basic requirement. So the basic regulation is online coursework is limited, and then in the spring when the COVID-19 situation started and schools were closing their campuses, ICE provided some flexibility to allow students to continue their studies even if their schools moved online. That is the policy that now continues to be in place. They did not go with the new policy that was again going to block these online programs. The important thing to be aware of is with where we're at with the old policy being put back into place, that policy applies to existing students that allows them to attend courses online. It does not seem to apply to new students.
What do you mean if somebody is coming from outside the country, let's say for example from Saudi Arabia or China, so this policy is not applicable, they still have to go to live classes?
That seems to be what the Trump administration's kind of next plan is that they won't be issuing visas for people who are coming into
What
the
about
US?
the people who are changing the status from, let's say for example, H4 to F1, B1 to F1? What about them? Is that, can they attend only online classes, or they will be forced?
Our guess is no, they won't be allowed to attend only online classes. So if you are planning on being in the US but changing your status to F1, you'll have to keep an eye out for new guidance that we're expecting. And if you're outside the US waiting for your visa appointment and your school is doing only online, you may still be subject to this type of guidance.
Now we are very close to August when the college starts, Emily, and we have had consulates, most of the consulates are closed from March to all the way to right now, and you're telling that the consulates are reopening. So what do you feel? Can all these students right now get an appointment and get in time to the schools? And then we still have a limbo with regards to whether or not they will be allowed for online classes only or not. You're saying that the consulates are beginning to reopen, so are they giving the visas, or is it only for emergency people?
So it depends on the consulate, and interestingly, everything that's going on with the consulates we're finding out by tweets rather than by actual public guidance being posted. So the State Department tweeted that consulates and embassies will now start to slowly do a phased reopening of visa services, so that's a good sign, but they say that you have to check the individual consulate's website for updates on what they're doing, because each individual consulate is dealing with whatever's going on with the virus in their location. So if their location is seeing a high number of cases, they may not be reopening. So what we're seeing from individual consulates is some of the consulates are specifically only opening for F-1 student visa appointments. And then others that fall under the different proclamation exemptions and that sort of thing.
So they're giving preference to the student visas right now.
They do seem to be. So hopefully the schools that those students are attending will be doing in-person classes, so they'll be able to get the visa to come in time. Other schools I'm hearing are deferring the attendance to the spring semester because they don't think the visa will come in time, because you generally have to travel within the 30 days before your program start date.
And then they have another additional burden of the attending the live classes, which most of the universities are reluctant to conduct at this point of time. So they can attend the online classes and come for the next semester. Emily, on the consulates being reopened now, there are also other questions now. What about the executive order? Are there any exceptions for the executive order? For example, if somebody is a medical doctor and they're working on COVID, and then can they apply for the H-1B stamping in India right now? If they're an H-4 EAD and they're a doctor or working in the COVID research, can they apply for the visa? Can they grant the visa? Because there are some exceptions given.
Yeah, the exceptions are very limited. Specific provisions for people who are working with COVID patients and food supply and that sort of thing. And then there's kind of more of a catch-all for people who would be in the national interest to come into the U.S. So that's where most people who might be able to get this exemption would fall under. So you have to basically make your case to the consulate of why it would be in the national interest to allow you to receive the visa and come in, even though there's currently an executive order stating otherwise. There is no guidance out there on what is considered national interest, what documents you have to submit, what the process is. So we're all kind of just making this up as we go, trying to make the best arguments that we can. There's a list of specific critical infrastructure areas that the government has put out since we've been dealing with this COVID-19 situation, and if you can make an argument that your work falls under one of those areas and is therefore in the national interest for public health, public safety, or something like that, then you maybe should get a letter from your employer explaining the importance of your work, explaining what the company does and how it is helping the community or helping the economy, economic recovery, and submit that to the consulate and request that you be granted a visa.
Emily, let's discuss about this executive order, merit-based system, which he has been commented about. What are the probabilities that this executive order can be implemented? What are the legal challenges that you feel about this executive order? And you said that he's been kept on changing. It's going to go to legislative thing, and then he said it's an executive order. Which one? I mean, Congress at this point of time seems to be that it's deadlocked. It doesn't look like it's going to pass any legislation that is not involving in the employment or COVID. They don't look like they're willing to take up any major immigration legislation. And this Trump is telling that, oh, this is going to be legislation or the executive order. Can he just pass a law change the entire immigration and make it as a merit-based system by an executive order? Can he do that? I know the parliament, which we call Congress here in the United States, the parliament can do it, but can the president do it by himself without going to the Congress?
Luckily, no, because who knows what he would come up with if he had that much power. So the legal.
So if he cannot, then why is he making this noise?
Right. Yeah. Again, it's all about chaos. It's all about let me throw this idea out there and see how the public responds. We're in an election year, trying to, appease his base. who wants to limit legal immigration, make it harder to come here, and everyone is talking about ending chain migration and making it a merit-based system. So he's throwing those words out there in order to make his base happy. That's my guess. I don't think there's anything that he can actually do by just a simple executive order to create a merit-based system. I think he can direct the agencies to propose new regulations that may make it more of a merit-based system. That's my best guess, is what he might try to do, and all of that was as
so
part
it's not
of it.
like he's going to come up with an executive order and say, hey, if you have a master's degree, you're making $100,000, and if your spouse is also a master's degree, I'm going to give you the green card. No, he can't do that thing. So it's just to appease the base. So guys, if you're relying on this executive order to come in and then get the green card, please don't. Try to look into the alternative sources that may be available, but don't rely on the statements made by the president on the merit-based system. Emily, right now it's a COVID situation. Things are very bad, for a lot of people because of the health reasons. They can't go to grocery stores. They can't go. It's just they're living in jail, and a lot of different things. They're going in mental circumstances. Then we have the biometric systems, which is not there for 4 months. The consulates are not there for 5 months. And then now we have an executive order to bar the H1s, L1s, and H4s, and L2s, and J visas. They cannot come into the United States until January of 2021. And now there is a fear that is coming up. The whole immigration system might be shut off on August 3rd if the Congress doesn't fund. I mean, even if it's not the entire system, but it may be only a 1/3 of the USCIS. I mean, that's going to be a huge backlog if he does that. The government, since the Trump administration came in, they have changed the policies on immigration without going to Congress more than 100 times. That has driven the USCIS to be bankrupt right now. What do you suggest the people who are here on a non-immigrant visas? What are the things that they can take care of?
Yeah,
what is the solution for them?
Yeah.
I mean, what can they do to be in a safer way?
I think that one of the things you should strive for is to always have a valid I-94. For the policy has always been that once you file an application for an extension or an application for a change of status, you can stay in the country in a period of authorized stay while it's pending, even though your I-94 expires. That policy is still there, but it puts you at much greater risk, because if whatever you ultimately filed gets denied, and your I-94 has expired, it's very difficult to overcome that without leaving the United States. So my first suggestion would be, whatever you're filing, check the processing times, make sure you file it early enough so that you get an answer on it before your current I-94 expires. Premium processing is a good way to make sure that happens. If you've got something that is planned to be filed soon, file it before August 3rd rather than waiting until a potential furlough happens. Those are the things that are kind of somewhat in your control that you could do. And also consider backup plans. We have a lot of people who, we have two spouses that both have H-1Bs, and maybe one of them has to file an extension. You could also file a backup change of status to H-4 and have that pending just in case something goes wrong with your H-1B extension. So think of what backup plans you could do to kind of file just in case. I know it's more filing fees and more money and more effort and all of that, but it could definitely save you in the event that something gets denied after your I-94 expires.
Emily, I want to go to questions. The questions are coming on the executive order directing to further restrict more within 30 days after the executive order has been given, particularly on the H-4 EADs. We know this administration wants to get rid of H-4 EADs. What are you personally or your office doing if the administration decides to take off the H-4 EAD, either through the executive order or through the regulations, what are you personally doing to see if the H-4 EAD can continue, and anything what your office is doing?
Yeah, obviously, we've been talking about the possible H-4 EAD being eliminated. Feel like since Trump was elected, we've been talking about it, and we've been telling people it's not going to happen overnight. It'll take time, and they're going to have to go through the regulatory process. I don't think it can be done by an executive order, but we do know that the current regulation that is planning to eliminate the H-4 EAD is now scheduled to be published in September. So that's right around the corner, and it does seem like the Trump administration is moving forward with that. So if he gets reelected, I think now is the time to start planning for what we can do to avoid losing the H-4 EAD. So our firm is actually in the process of starting a nonprofit organization called Save H-4 EAD. We're going to use that organization to educate the public, educate policymakers about why this EAD is so essential for so many people here who are one step away from being permanent residents. All they're doing is just waiting, and they have to wait decades. Do they really expect people to sit around and do nothing for decades? So I think so much of it is giving a human story to support the need for this, explain the people that it's actually impacting. So we're starting some social media efforts on that to share stories of people who have the H-4 EAD and how it's affected their life and what would happen if they were to lose that. We're going to be working on some surveys and some research reports that we can use when this proposed regulation comes out. It will have a commenting period, and we want to be ready with the data to be able to submit our public comment explaining why the planned rescission of the H-4 EAD is not the way to go. It's not going to help our economic recovery. It's not going to save American jobs. They have no data on their side to back up eliminating this H-4 EAD. We want to make sure we have plenty of data on our side and publish those comments, put them on there, and then when they finally do decide to issue a final regulation, be ready to litigate it, because we'll be able to use those comments that were in support of keeping the H-4 EAD to show that the government's actions are arbitrary and capricious, which is the reason why everything they've been doing gets overturned. So we're taking steps now to be able to provide those comments, educate the public, advocate on behalf of keeping it, while other immigration reforms continue to go on. We're not suggesting that the H-4 EAD is the only valid way to help people, but it's something that people need right now while other efforts are going on, and we want to make sure that we keep that alive.
Is there a website you already have it, Emily, that you can announce it?
I do not have that yet, but if you follow me on Twitter, I've been sharing some recent stories, some recent quotes from people who are using the H-4 EAD and how it impacts them, how it helps them. And so in that, I have some links that you can sign up to receive updated information. So if you check me out on Twitter, Immigration Girl, Facebook as well is also Immigration Girl, or find me on LinkedIn, Emily Newman on LinkedIn.
Emily, have you conducted any surveys, or you just only word of mouth things that what you're speaking about?
We did conduct a survey of 10,000 H-4 EAD holders and put together a lot of great data from that, put together a report which we're using to also provide more information and support for keeping the H-4 EAD, but we want to go even further, make sure it's done by a reputable economist or someone who has strong skills in that, so it stands up to these comments.
I got a question from Samant Saligram from YouTube. He wants to get an update of the I-485 inventory. I'm going to try to put that on the Facebook account of Radio Newman PC. You can check it out, Samant. I will try to put it out by end of this week.
Have they updated it though?
I don't. I'm going to get the previous one, what
okay.
has been done, not the recent. The latest one. They may not have updated it. There are a lot of questions coming, Emily, now. First is, I want to ask you this question: when does the executive order that is banning the H-1Bs and H-4 stampings to come into United States end?
So as of right now, that lasts through December 31st.
What assurances can you give that that is the last date?
I would say if Trump wins the election, that won't be the last date unless we can overcome it in litigation.
Do you have a litigation process for it where if, for example, I'm an H-1B, can I go to court? And if I'm stuck in India, can I go to court to get my visa stamping?
Yes, we are working on that right now. So we are kind of at the early stages of that. We're putting together a list of information and documents that we'll need to have a questionnaire created for that, very similar to what we've done for the H-4 EAD litigation in the past. And so stay tuned for that. We'll be sending out updates. We'll share it here on how you can be involved in that litigation if you or your family member is stuck outside the U.S. because of this ban.
The questions that are coming up related to the EB1, EB2, and EB3 movement. Now we know that the priority date is stuck for a long period of time, though, Emily. Now we have said many times before in the YouTube and Facebook that the unused family preference categories will fall into the employment based. Since most of the consulates are closed from March and there was an executive order until June 30th where you cannot get the family immigration, and that is now extended, family preference immigration. Now that is extended all the way to January 1st of 2021. So a lot of family preference categories are not been given because most of them come outside the country. So those extra green cards should be given to the employment base starting from October 1st of 2021. Mm-hmm. So what do you expect? We already have a statement from the State Department that there are X amount of green cards available, extra available next year. And now, after that statement, there are more not being given. What do you expect? Do you expect some great movement in EB1, EB2 starting on October 1st of 2020?
Oh, that's anybody's guess because we don't have an inventory. We don't know how many people are.
But at the same time, we don't have the adjustment of status also going on right now. Mm-hmm. Those people who file the adjustment of status, the Trump administration have put a policy that they have to be interviewed. Now, there haven't been any interviews conducted from March onwards until July, until today. They're expecting to conduct more, but there are also more employment-based green cards that will open up. Mm-hmm. I'm expecting a good amount of movement in the priority date. What do you expect?
I would say that we might see a good movement in the filing date chart. Mm-hmm. Because the problem is the processing times. So they can't move the final action date chart too far forward because they can't process all of those applications fast enough. So they use this filing date chart that gives us an idea of where they think the final action date might be by the end of the fiscal year. So that date might see some vast movement, and then it's going to be up to USCIS whether they allow us to use the filing date chart versus the final action date chart, which they normally have in the month of October.
The State Department is answerable to the Congress why they have not used the numbers when they were being given the employment-based number and family-based numbers. Is there a chance that it could be current for employment-based 2 and employment-based 3? What it happened in, you remember in 2007, mm-hmm. where the whole confusion and the State Department has to answer to the Congress and they don't want to answer to the Congress. They said every priority date is current EB2 and EB3. Mm-hmm. Is there a chance for it that could happen next year? Next year means starting from October 1st of 2020.
I don't see it. I don't know about your thoughts.
Yeah, I don't think so. At this point of time, I'm expecting all the dates to be current, but I do expect that a great movement in the EB1 and EB2 and probably EB3 also. That's my expectation. Let's see how it goes on.
All right. Some of the questions we've been getting are with the Perm process and the notice of filing requirement. So I want to address that real quick here. So normally, as part of the recruitment steps for the Perm process, a company is required to post a notice of filing, a physical hard copy notice, at the work location where the person is going to be working. We have lots of companies that, since these shutdowns and lockdowns have happened, have moved to 100% remote workforce, so no one's actually in the office. So if they were to publish this notice of filing and post it at the office, number one, they might not be able to get to the office to do it, but number two, who is going to see it? And so there's unfortunately been zero guidance from the Labor Department giving us alternatives to this requirement. So some employers are choosing to go ahead and post it, proceed with the process, and also give notice to actual workers by email or using the company intranet site and telling them to go look at the notice there. Some employers are thinking that's too much of a risk and are choosing not to post the notice and are delaying the perm process. So it really depends on how the employer is proceeding with that, but we do think we have a solid workaround for it by posting the physical notice and sending out notice to the individual workers, the U.S. workers who are affected, so that we can document that they actually received the notice.
Ritesh from Facebook has this question: is it an advantage to file a perm with a smaller company as compared to the bigger company? Ritesh, I personally feel that smaller companies have a greater advantage in getting the perm approval. One main reason is that it's easy to reach the HR and they're a little bit flexible, especially in the perm labor certification. There are a lot of steps that the employer has to do. Sometimes they have to conduct interviews if there are eligible candidates, and maybe necessary if they can hire the people if they are eligible for, and those are the steps that can be done. So smaller employers have a greater advantage in perm application. Now when it comes to the H-1B, obviously the answer is that it's a bigger company has greater advantage. But when it comes to the perm application though, I personally think it's the smaller company that has more advantage. Emily, I need your attention on this one. There are a lot of people who are asking questions on Facebook and YouTube, is that if right now the lottery is over and the filing for until June 30th is over, in our office we noticed that some of the people that got selected in the lottery dropped out because either they lost the project or some changes occurred because of the COVID situation. Now, that's what happens with the remaining thing. That's one question. Another interesting question posted by our audience is that since the H-1B quota cases that we're supposed to get the visa outside this country is barred until January of 2021, can they give those H-1Bs and conduct a new lottery to the people here?
Okay, so I'll answer the second question first. No, I don't see that happening. Those people, even if they can't use the visa between October and December, that visa that they've applied for with USCIS is generally valid for 3 years, and they can use it anytime during that 3-year period. So it's not necessarily going to go to waste. It can still be used by those people. They don't have to use it on October 1st. So I don't see them, they're going to continue processing consular processed H-1Bs, and they'll approve them just like they would any other year. Just those people may have to wait in order to get the visa. As far as a second lottery, that is one of the things that the way they're doing this electronic filing, the electronic registration process, it does allow for a possible second lottery in the event that the cap is not actually filled. That being said, when they conducted that electronic registration lottery, I can guarantee you they picked more than 85,000 people in order to file their petitions, because they know every year a certain number of people are not going to go through the whole process. Some are going to be withdrawn, some are going to be denied. They calculate all of that in advance. Now this year, perhaps more people than what they originally thought are going to be not filing because of the COVID situation, because that didn't exist at the time they conducted the lottery. Will it be enough people that they'll have to conduct a second lottery? I don't know. I think it's a pretty low percentage, at least in our office. Yeah, there are some industries that are more hard hit than others in this situation, but the H-1B is used by a lot of technology companies, and technology companies are still in high demand. The jobs are still out there. Who's making sure these Zoom conferences are happening and that remote work can happen, and providing new services and online retail and all of that, it's all still happening. So I don't see the numbers being so low of people filing that there'll be a second lottery, but it's anybody's, it's hard to predict.
Garde from YouTube, Mr. Garde from YouTube has this question. Can he file the H-1B extension beyond 6 years using the I-140 receipt notice? Technically speaking, you cannot file the extension beyond 6 years until you have the I-140 approval with you, unless your labor certification has been filed for more than 1 year ago and you have an I-140 pending. You cannot file while I-140 receipt notice is there. You have to wait for it to get it premium processing approved. I don't know if you have not already done the premium processing for I-140, do it immediately. Reddy Sri from Facebook has this question. Can you legally do 2 jobs for 2 different employers on H-1B? The answer to the question in one word is yes. However, though, the second company that is filing for the H-1B, they have to file it with it is called as concurrently H1. Concurrent, that means that you have one H-1B, the second H-1B is concurrent. So you have to inform the second employer that you're working with employer 1 and you don't intend to leave, and then you go to work with employer 2. Can you file first employer with 40 hours? Can you have second employer with 40 hours? Yes. I know a lot of people who work for 80 hours. I mean, I work a lot of time too, but there's nothing wrong in people working for 80 hours. This is a capitalistic society. We want you to work harder and pay more taxes. That's good for us. So absolutely nothing wrong in working for 2, but make sure that second employer files with a concurrently working. So that's absolutely needed for you to work for a second employer.
Okay, I'm seeing a lot of questions about the I-539 biometrics appointment process, the rescheduling of those, and what's going on with it. So I can confirm that our office has started receiving biometrics appointment notices again for I-539 applications. And it all depends on the application support center that you are going to be sent to and what's going on in that location. So there is on the USCIS website, there's a list of all the application support centers, and they all have an expected reopening date. Some of them reopened this week, another set of them as of right now look to be reopening July 20th, and another set possibly July 27th. So we have started getting the biometrics notices for cases that were filed in April and May. For some that were filed earlier than that and had their appointments canceled, we seem to be seeing a slower response in getting those biometrics appointments compared to people who filed more recently, which doesn't seem fair. I'm not sure what we can do about it at this time. But one other thing I want to mention is right now the notices that we're getting in the mail, they're not giving you much advance notice of your appointment date. So we got several in the mail today that were mailed to our office on, I believe, July 6th is the notice date, and the appointments were scheduled for today and tomorrow. So we barely got them in time for them to attend their appointment. So just keep an eye on your mailbox if you're expecting to get an appointment, so you get it immediately.
A question that comes from Chetan is that, do people who have approved for EB2 NIW, are they eligible for filing, for going for stamping? Don't assume that just because you got a national interest waiver from the EB2, that the consulate will apply the same standards in giving you the H-1B or J-1 visas. We don't know if they're going to use the same standards or they're going to use a different standards. So that part is yet to be tested. You can definitely try. If you are already outside the country, I would strongly recommend you should try definitely to apply for the visa. But if you're here in the United States and you're planning to go outside the country and get the stamping, our advice is don't do right now. Let's wait and see what the other people will get it, and then later on then you can plan accordingly. Another question that comes up is that are you resuming the H4 EAD delay lawsuits from Rescheduling and PC? Not at this point of time. Stay tuned. We will update you. The heading of the YouTube and Facebook will be that topic when we start resuming. We're getting a lot of inquiries in our conference calls and also in this. Please stay tuned. We will let you know.
Another question I'm getting a lot is for the H-1B cap cases that were filed in June, we're still waiting on receipt notices. So especially people who filed towards the end of June, the deadline was June 30th to file. We have a number of cases in our office that were filed in that time frame and still don't have receipt notices, so that is normal. The problem is, what do you do for your cap gap extension if you're needing that, if your OPT is expiring soon? The schools generally are requiring you to provide the actual receipt notice before they will give you the I-20. So that's something that you may have to work with your employer on, see if the filing fee checks have at least been cashed, and maybe you can get the receipt number off the back of that. But yes, we are experiencing delays in getting those cap receipts for cases filed towards the end of June.
One second. Is it, Amit from YouTube has this question, is it mandatory for the employer to do the I-140 revocation when an employee leaves the company? It's not mandatory. It's mandatory for them to revoke the H-1B, but the I-140, it's not mandatory. However, it is customary practice for a lot of companies, since you already left the company, to revoke the I-140. So that happens. But one thing, Amit, is that if the I-140 has been revoked, after 6 months it's been approved, and after January 17th of 2017, you can still use that I-140 to get the extensions of the H-1B however long you want to. You can use the same I-140 to get the EAD approvals even though it's been revoked, as long as it's been revoked after January 17th of 2017 and after 180 days, you can still use it. But yeah, we have seen that some companies don't revoke and some companies do revoke. That's up to the company though.
Sarah Bonin from YouTube wants to know what the current processing time is for Perm and I-140. So currently the Perms are getting approved in about 4 to 5 months if there's no audit, and then I-140 processing, you do have the premium processing option, so that can be approved in as little as 2 weeks.
PC Party from Facebook has this question. He has an approved GCEAD. He has filed an EB1 in adjustment of status in April of 2018. And when can he expect his green card? Assuming the priority date is still current, that's absolutely required. If the priority date has backlogged though, they cannot grant you the green card right now. You will get the EAD extensions, but you will not get the GC unless the priority date is current. If the priority date is current though, the timeline to process the adjustment of status is approximately 2 years. Now, having said that, please add COVID in it, and that changes the entire equation. We have noticed that since March of 2020, the USCIS has delayed especially the adjustment of status interviews. They haven't conducted any interviews from March onwards all the way to right now. They are saying they're going to conduct some interviews, but we haven't received yet any notices to be conducted for the adjustment of status interviews. So that may delay the entire timeline, what I said to you in the 485 process.
Harry from Facebook wants to know if you can file an H-1B transfer if an extension is also pending and has an RFE, but the I-94 has not expired. So when the I-94 has not expired, if you have a valid job offer with another employer, yes, you can file a transfer. And that's something kind of I mentioned at the beginning about what things you can do in all of this uncertainty is maybe have a backup plan and consider filing a transfer to another employer or filing a change of status if you are eligible for it while you've got your extension pending before your I-94 expires, because that can save you in the event that your extension gets denied.
One question that came up is Madhu from Facebook has this question. Can I get the status of my I-140? My employer is not giving the information. A lot of people whose I-140 has been approved though, okay, if it's been approved, and it's been approved for more than 6 months, we always recommend them to get an official copy from USCIS, because having an I-140 approval and being counted toward the H-1B is practically the similar thing of having a green card in our old time. I mean, there's no green card for you to have an I-140 approval for more than 6 months. We do recommend that you do file a Freedom of Information, FOIA, and you can Google it, USCIS FOIA, and you can fill an online form, and it takes about 2 to 3 months plus. Please add COVID, it may be 4 months right now. They will send you online I-140 petition that is useful for many different purposes. I strongly recommend that you get it. But in your case, Madhu, though, if it is just pending right now, you can file the Freedom of Information. It will take about 3 to 4 months, but if you call the USCIS, they will not give that information to you, because they will say that it's an employer information. They will not give it. You can file a Freedom of Information. As I said to you, it may take 3 to 4 months for you to get that information.
Anchor from Facebook wants to know if we really need to get documentation from the end client when we're filing an H-1B extension now. So this is related to recent litigation done by ITserv that was able to cause USCIS to rescind some memos. So we had the 2010 Neufeld memo and then a 2018 memo regarding contracts and necessary documents for third-party placement situations. Both of those memos together almost mandated that you had to have a contract, a work order, and a letter from every party involved in the employment situation. Those memos have been rescinded under a settlement agreement from that lawsuit. So it's not mandatory to have an end client letter. That being said, the company still has to be able to sufficiently document that they have specialty occupation work available. An end client letter can be a good way to document that, because the end client is usually in a good position to explain what the job is, what the duties are, and what the education that would normally be required for someone to carry out those duties. So I wouldn't say that no one needs an end client letter anymore, but it is less of an issue if you have other strong documentation supporting the specialty occupation work.
Srinivas from YouTube has this question: do you know which processing centers will affect more if the furlough of the USCIS happens? Have no clue, Srinivas. I can't judge which ones they're going to furlough more. We don't know which priorities they can give, because when the furlough happens, though, the USCIS gets to choose, okay, H1 is a priority, H4 is not. They may pick and choose. We don't know at this point of time which ones they will pick and choose. We can take a guess that everything will be delayed, for sure, I can say that. But as such, which ones they're going to give priority, which ones they're not going to give priority, it is not going to be clear at this point of time. They will let us know at a later time. Secret Santa from YouTube has this question he's been asking. He filed his 485 application and EAD application May of 2020 because of the situation of the COVID. He didn't submit the medical and he didn't submit the photos. Can they reject the 485 because of that? Assuming that you already received the receipt notice, Secret Santa, they should not reject your application for the 485 just because you didn't file the medical or photographs. So, as far as the medical is concerned, though, they will not reject absolutely. They will not reject at all. But as far as the medical photographs are concerned, though, what I strongly recommend is that if you have received the receipt notice, you can do something called internal interfiling. Use the word one, interfiling, and send the receipt notice copy and send the passport size picture. So, because you may avoid the RFEs if you choose to send the photographs, and if the photograph reaches the file, then you will be able to get the EAD without any RFE. Otherwise, they will have to issue an RFE for you that will delay your EAD. So interfiling and send the photographs, that will save your RFE.
Rohit from YouTube wants to know if it's a good idea to go with premium processing for the H-1B cap case because the STEM OPT has already expired and he's using the cap gap. So there's two thoughts to that. Number one is, if maybe it's not so strong of a case and you upgrade to premium, once you get that application denied, your cap gap ends. So you have to stop working at that point. So that's kind of one side of the coin. The other side of the coin is that your cap gap ends on September 30th, and so if you don't have an answer by that point, you have to stop working anyways. So there's a benefit to making sure that you get the H-1B approved before October 1st so that you don't lose your employment authorization due to long processing times. So I generally think it's a good idea to have these cases filed in premium processing. I'm not noticing any difference in how they're being adjudicated. We're getting approvals in premium just like we're getting approvals in regular processing. No difference in RFEs. So I think that the chances of the case taking longer than September 30th are quite high based on what we've seen in prior years. And so to avoid losing your employment authorization, premium is a good idea.
Pisipati is updating that his 485 has been interviewed in April of 2019. He still did not get the green card. That, if your priority date is current, that is definitely not a good thing what happened to you. You may consider litigating in the court because that's a too lengthy of a time for you to receive the 485 application after the interview process has occurred though. Prajit Kumar from Facebook has this question. Can I port EB2 priority date to EB1? Yes, you can port from EB2 to EB1. Absolutely allowed.
Cheng Leo from Facebook points out the processing delays in getting EAD and green cards printed by USCIS after the approval happens. We haven't felt that so much in our office, but there are definitely reports of it happening, taking up to a month to get the EAD card in the mail after the approval notice because USCIS doesn't have the resources to keep printing them timely.
They're saying that they don't have money for the ink to print it. That's very surprising.
Yeah.
I don't know what they're doing with all the money we're giving it to them.
Exactly.
One of the main reason why this administration has broken this USCIS in insolvent, they did it purposefully according to me, is they changed their policies more than 180 times once they came in. And to keep up with the changing of these policies is what took the USCIS to bankruptcy. Imagine that there was no biometrics for H4. Things used to get approved. H1, H4, and H4 EAD used to get approved on the same day. Now we have biometrics. It delays the entire thing. It was not there before. Then we have this called 944 form with the adjustment of status. We didn't used to have 485 interviews for the employment based. Trump administration came and introduced those things. These are all different policies. I think so that this administration has intentionally incorporated into it to drive the USCIS into insolvency, and that's where the problem is coming.
Yeah, so what do you do if you've been waiting on this EAD to start working and you need it to do the I-9 verification process and it's not printed yet? I think litigation really is your only option there. Not very user friendly, it can be expensive, so a lot of people just end up waiting for it at this point, but litigation would be one way to speed up that process.
Emily, I want your attention on this one though. A lot of people are asking the question. They are eligible for H4 to apply for the visa, to get the visa, and they are eligible for L2 visas. Of course, the executive order, they know the executive order, they cannot apply right now for the visa. Can they apply for the visiting visa to come into the United States?
So technically the answer is yes. If you are eligible for a visitor visa, you can apply for that because there's no ban on that right now. But what you need to make sure you're aware of is that the purpose of the visitor visa is different from the purpose of the H4 and the L2 visa. And the visitor visa does not allow dual intent. So if you or your spouse has been in the United States for a long time, has a green card process going on, has an approved I-140, that shows you have immigrant intent and may make it impossible for you to get a B2 visa to be able to come in. But if you have non-immigrant intent, If you can convince the officer that the purpose of your entry to the U.S. is simply to visit for a short period of time that is a defined period, and you convince them that you will return back to your home country at the end of your stay, then you can be eligible for a B2 visa. Problem is, a lot of dependents won't be able to convince the officer of those things, and they'll get the application denied.
I have another problem also, Emily, is that most of these people may not intend to just visit the husband or the wife. They may intend to join them. So that defeats the purpose of the B2. I'm a bit fearful that any statements these people make, and if there is any contradictory information that they have available, they may be hit with a misrepresentation and then may have a permanent bar because they applied for B2, Emily.
Yeah, I mean, they have to be very clear that they have a family member in the U.S. that's in H1
Of course, they are going to, in the
you
DS
know.
160, they're going to say that.
Yeah.
But let's say, for example, the person says, I'm going to only go and visit my husband and come back. While, let's say, there is a WhatsApp or there is an email that says that, oh, I'm just applying this B2 so that I can come and change the status to H4. That by itself is a misrepresentation, might get a full bar. So I strongly recommend that if you're taking any B2 though, B2 application process, I strongly recommend that you get completely screened by an immigration lawyer to make sure that you are just coming only temporarily, and then you're going to leave afterwards though. I don't want any of you guys hit with misrepresentation. That will be a permanent bar for you to come into the United States. In general though, my advice at this point of time is do not apply for the B2 visa if you are eligible for H1 or H4 or L2 or H1 or L1. Just wait until January of 2021.
Another question, this is from Shanawaz on YouTube, and he wants to know if there's any impact on OPT as of right now. So that was one of the areas of concern with this latest executive order, is what is the president going to attempt to do with OPTs? There's a lot of talk about restricting optional practical training and putting more oversight on that. So none of that actually happened in the executive order. That being said, we've had it on the regulatory agenda for some time that we're expecting a new regulation to be proposed that will modify the OPT program, likely to make it more restrictive rather than less restrictive, more oversight, might even shorten it. We don't know. It's just on the agenda, and I believe we won't see a proposal on that until this fall. So it's not something that's going to happen in the near future, and it does have to go through the regulatory process.
Does USCIS work on Saturdays too? Not usually though. We have not seen them working for the interviews and certain things. We have not seen them working on Saturdays though. Have they ever worked on Saturdays? Yes. When Bush administration came into power though, everything was delayed, and the Bush administration gave a warning to all the USCIS district directors that try to get the processing time down. He gave them 6 months. After 6 months, he went and he reviewed, and the processing time went more further. It did not come down. Then he told, the Bush administration fired all district directors. He told that you're fired 6 months from now. Not immediately. He fired from 6 months from now, you're fired because you didn't cut down the processing time. Guess what happened in that 6 months? Ooh, the USCIS started working on Saturdays, even Sundays. I've even gone interviews at 6 p.m. in the Saturday, and that's how they conducted it, and they brought the timings, especially in Houston, from 4.5 years to 6 months in 6 months' time. So if the administration has the will though, they can make them work and they can make the process quicker. But this administration intentionally wants to delay the entire process. There's not much anybody can do. If the head of the administration wants it to be delayed, there's nothing anybody can do.
Sachin from Facebook brings up another part of the IT-Serve litigation that rescinded some policy memos about these short duration approval notices, and wants to know if now we're able to get 3-year approval notices without end-client letters and things like that. So you're correct that USCIS was improperly shortening approval notices, and the litigation argued that that short approval notice is practically a denial of every day that they've shortened the approval. And the regulations, the statute requires anytime USCIS denies something, they have to give a reason for it. So with this, after the lawsuit, can USCIS still issue a short approval? Yes, but to do it, it's more hassle for them. They have to actually issue a decision explaining why. So since that time, the only decisions I've seen regarding short approval notices are in situations when we filed to recapture some time and there was a difference in counting the days in and outside the U.S. and they gave us a shorter amount than what we requested, and they did give an explanation as to why. I haven't really seen short approval notices recently due to client contracts expiring or things like that.
The question that is that Benny from Facebook has this question. In the past 2 months, I've seen that the priority date has moved up to 2 years in EB1. Is there a chance that it may become current soon? Benny, I have gone wrong in estimating the priority dates 1,000 times, and that's a lie. It's probably more than that. But let me do one more time. I do expect forward movement of the EB1 in October. And I'm guessing right now, I may go wrong, as I said 1,000 times I did, is that I'm expecting priority date for the EB1 for Indian nationals to be current on October 1st. That's my guess. Let's see if I'm going to be right.
A question about an I-140 denial and ability to get an extension beyond the 6-year limit. This is from Girish on YouTube. So normally you need to have the I-140 approval to get a 3-year extension beyond the 6-year limit. However, if the I-140 has been denied, if it's not yet a final decision and you meet the 365-day requirement, you may still be able to get a 1-year extension of the H-1. So your employer would need to file an appeal, and that pending appeal is considered as if the I-140 has not yet been denied. It's still pending, and if that meets 365 days from the time the labor was filed till the time you are needing to extend your H-1, you can qualify for a 7th-year extension.
Josh from YouTube has this question. Can we express that I want to permanently immigrate into United States at the time of the H-1B issuance in the consulate? Yes, you can. That's not going to cause any problem whatsoever at all. If you have an intention to permanently settle in United States, you're applying for H1, L1, H4, or L2. That is not going to cause any problem. In the DS-160 form, they ask you the question, have you ever filed an I-140 application? Yeah, you can say, yes, I did. And that's not going to cause any problem whatsoever at all in getting your H-1B or L1 or H4 or L2.
All right, well, I think we're about out of time for today. Thank you all for joining us. If you want to get the latest updates, you can follow me on Twitter @ImmigrationGirl or subscribe to my blog, immigrationgirl.com. If you would like, if you didn't get your question answered today, we also have a daily conference call where we answer questions just like this. You can get that login information at rnlawgroup.com.
Don't forget that you can always make an appointment with any of our colleagues or with me or Emily at rnlawgroup.com. Our schedule is available online at RN Law Group, so based on what timings are suitable for you, you can make an appointment. A lot of people ask the question, in my appointment, can I have other people join, my friends and my family? Yeah, it's your time. I mean, it's your time. So we allocate the time to you. If you have 10 people, that's up to you. I mean, we will answer the questions of the 10 people. We don't care, how many people are there on your side. It's fine. So you can make an appointment with me, Emily, or any of our colleagues at RN Law Group. Our schedule is available. Thank you guys for tuning in. Be safe and wear the masks.